Will the resource speaker agree if I would say that a spokesperson position is a position of trust and confidence?
Yes, Mr. Chair.
And by position of trust and confidence, that President is giving you full trust and confidence in all matters that might be within or even relevant to charge of your function as presidential spokesperson. Does the resource speaker agree?
Mr. Chairman, subject to regular consultations with the President.
And for the information of the committee, by the position of trust and confidence, the moment the President lost the trust and confidence, the person can anytime terminate this official.
I confirm that, Mr. Chairman. I was appointed to a position rank of cabinet.
I understand as well that Attorney Roque is one of the senior lawyers, the matter of fact, internationally. Can you please enlighten us on your background as a lawyer?
I have been teaching international law in UP as well as in American University, National University of Singapore, total of more than 20 years already until now. And I was past president of the Society of. I'm also a member of the List Council.
And having earned that reputation in the legal circle, Mr. Chair, and being the presidential spokesperson as well, I would assume that ever there will be erroneous decision part of the President, Attorney Harry Roque, calling the corrective, perhaps stopping President from pursuing such erroneous action. Will the resource speaker agree to this?
I do not think I had that function. I could only speak for the President. I could not actually countermand him. I could not correct him. He is my principal.
But considering, Mr. Chair, that he is a lawyer and a spokesperson as well, pagka ho ba may maling desisyon ang Presidente, will you not volunteer for legal expert correct the President?
Unless I am asked for my opinion, Mr. Chair, I will not volunteer, Your Honor.
Mr. Chair, I wish to invite the attention of Attorney Harry Roque to PD 9. This is described as the Charter of PAGCOR. And as a matter of fact, it defines what illegal gambling is. I also wish to invite his attention to Republic Act number 9487, which extends franchise of PAGCOR another 5 years. Again, it defines what illegal gambling is. Ultimately, Mr. Chair, I wish to invite the attention of Attorney Roque to Executive Order number 3. I wish to state for the record, Mr. Chair, that for the very first time, the term online gaming was mentioned in Executive Order number 13. This is something which is not mentioned, which is not provided in PD 1869, as well as in RA 9487. May I ask the resource speaker, when the President issued Executive Order number 13, don't you think he legislated?
I am unable to make an opinion because when I was a spokesperson, legal matters such as these are directed to the Presidential Legal Counsel or to the Office of the Solicitor General or to the legal office of the Office of the President under the Executive Secretary.
Mr. Chair, this representation wishes to solicit the opinion of expert, our resource speaker, Attorney Harry Roque, that number of things he has come across Executive Order number 30. This is the potential issue time of Roma Duterte mentioning online game time. Term that was never mentioned, PD 1869, and even in RA 9486. I hope we can be enlightened by the legal experts of our research. When the President should go number 3, fighting for the term online game time, don't you think, Attorney Roque, the President legislates?
Again, Your Honor, I am unable to answer because that is not within my expertise. I've mentioned that my expertise in the field of public law, having taught and practiced that, and I am sorry because I'm not very familiar with Executive Order number 13. In fact, my only knowledge of Executive Order number 13 was in the last hearing when former Chair Domingo said that President Duterte regulated online gambling, no, through Executive Order number 13. But I am unable to give an opinion now, not being thoroughly familiar with the EO as well as the underpinnings behind the issuance of Executive Order number 13. I'm so sorry, Your Honor, it's not within my field of expertise.
With all due respect to our resource speaker, Mr. Chair, I find it strange na sa dami po ng hearing na ina-attendan niya, both in the Senate and in the Congress, all pertaining to BOGOs, he have not come across EO number 13, from which the POGOs or the online gaming started. But I'm sure for the next concern that I wish to raise, our resource speaker is very much familiar with, because this is fundamental in the study of law. There is in law the principle of separation of powers. And I wish to share the case of Belgica versus Ochoa, GR number 208566, November 19, 2013, on the constitutionality of the Priority Development Assistance Fund. For the information of the Filipino people, I wish to read. The principle of separation of powers refers to the constitutional demarcation of the three fundamental powers of the government. In the celebrated words of Justice Laurel Inangara versus Electoral Commission, it means that the Constitution has blocked out, with deft strokes and in bold lines, allotment of power to the executive, the legislative, and the judicial departments of the government. To the legislative branch of the government through Congress belongs the power to make laws. To the executive branch of the government through the President belongs the power to enforce laws. To the judicial branch of government through the court belongs the power to interpret laws. I wish to go back to Attorney Roque. Attorney Roque, don't you think that the President encroached upon the power of the Congress when he issued Executive Order number 13, providing for online gaming?
Well, Mr. Chair, first and foremost, I argued that case of Belgica. I was lawyer in the Supreme Court for Mr. Belgica, and I confirmed the principle of separation of powers. However, as I said, although it is not my expertise, I will give my opinion, my candid opinion. And that is, under our scheme of things, executive issuances, legislative enactments are all presumed to be constitutional unless proven otherwise. So the status of Executive Order number 13, unless challenged in court, is that it is presumed to be constitutional. Executive orders being in the nature of implementing existing legislation, Your Honors.
Mr. Chair, there's a principle in law. When the law does not provide, we should not provide. When the law does not include, we should not include. If the substantive law creating PAGCOR does not provide for online gaming, then no executive issuances should provide for online gaming. Let us all be reminded by the legal maxim, inclusio unius est exclusio alterius. Kung wala naman pong sinabi dun sa substantive law, then the procedural law should not provide. Let us be reminded that the procedural law should always yield in favor of the substantive law. Mr. Chair, I wish to invite the attention of the committee to Executive Order Number 13, the presidential issuance which provides for the very first time for the term online gaming, the term that was never mentioned in the legislation that was passed by Congress. In the 8th whereas clause, it says, clarifying the extent of authority of gambling regulators, particularly with regards to online gaming. And then we have Section 3, clarification on online gambling, which technically defines what online gambling is. And then under Section 4, Mr. Chair, it emphasizes the oversight function of the Office of the President over all forms of gaming, and that includes online gaming. I humbly submit, Mr. Chair, that EO number 13 brings online gambling into life. And I do not understand, Mr. Chair, why this should circumvent the law that was passed by Congress, creating the PAGCOR and providing the authorities to regulate all the gaming and gambling activities. Once again, Mr. Chair, I wish to raise the reason why the principle of separation of powers is very important. The principle of separation of powers and its concepts of autonomy and independence stem from the notion that the powers of the government must be divided to avoid concentration of these powers in any one branch. The division, it is hoped, would avoid any single branch from lording its power over the other branches or the citizenry. To achieve this purpose, the divided power must be wielded by co-equal branches of government that are equally capable of independent action in exercising their respective mandates. Lack of independence would result in the inability of one branch of government to check the arbitrary or self-interest assertions of another or others. To wind up, Mr. Chair, I wish to state for the record that when the President issued Executive Order Number 13, it is the humble submission of this representation. He legislated, he amended, he repealed the law, an act which violates the fundamental principle of separation of power. The executive should not encroach upon the power to legislate that belongs exclusively to the Congress. Thank you, Mr. Chair.
Thank you so much, Congresswoman Jinky Luistro.